Well, good evening, everybody, and welcome back to the garage for a Friday night for another edition of Andy the Gabby Cabby. Hope everyone is doing well this evening, and apologies for the brief delay, as can happen from time to time. There was a very last minute bit of technical difficulty. In short, I needed to get a little bit more information before we went live, but everything's all right now. As the title infers, enough is enough. I've got Noel Willcox in the background, and we're going to bring him on and have a chat this evening about what happened in London at the Royal Courts of Justice, and also blow the whole thing clear out of the water and tell you exactly why they're on a sticky wicket. So without further ado, let's bring on Noel. Say hello and we'll get cracking. Hiya, Noel. How you doing, mate?
I'm good. How are you, Andy?
Yeah, not too bad. Cold, miserable outside. It's getting dark and wintry, but apart from that, very positive and trying to do everything I can to expose things like we're going to talk about this evening.
I'll tell you what. Oh, yeah, it sounds good. I'll tell you what this weather is about as depressing as the Labour government, isn't it?
Oh, I know. And that's another life for another time. You have to be careful what you say these days, as you'll end up with 31 months in the nick for your pleasure. So that's something.
Tell me about it. I know.
Well, as regular subscribers of the channel will know, this has been an ongoing, we'll call it a saga, which, I've been covering along with you for all this time. And we ended up in court, the Royal Courts of Justice. There's a couple of snaps just to show everybody here what went on. This is us outside the Royal Courts of Justice. This was after the hearing that we'll talk about. And you had some great support there as well. There was me with Howard Cox outside. I nearly called him Willcox like he was your brother or something. And also, you got jumped on by GB News. Now, I'm not very happy with them because they caught this guy outside a court of law in his shorts, his trainers, and his T-shirt. Didn't really look the part. And I think they got us from two different angles while they were interviewing you. So they could have done with a lens a little bit shorter, couldn't they? But there you go. Anyway, the important thing is what happened inside. We obviously went in there, and if you want to start from that point.
But just to give everybody a quick recap for those that are not aware, I won an adjudicator's decision back in October 2021 on the low emission zone, which is where my company, Elevation Access, which is a small scaffolding company, was fined £11,500. And it was where our depot was over in Harefield. So every time you went into that low emission zone, subsequently you were supposed to pay £100 for that vehicle to go in. That was the daily charge. But little did we know that scheme was actually operating because of the signage. And the signage became very, very clear to me that the signage does not give drivers the adequate information. So that's just basically giving everybody an overview of where we are with that. So I went to court on the 20th of March this year. 20th of March this yes, it was 20th of March this year. Sorry, I was thinking, hang on a minute, what month are we in? Was it last year? Because time is flying. And the district judge that I was in front of, he upheld that adjudicator's decision. And considered it a finding of fact, which is basically where the adjudicator stated that he was not satisfied due to the fact that Transport for London did not provide the evidence in time. He was not satisfied that the low emission zone was lawful, and he categorically stated that it is unlawful. So he said no charge or penalty charge applies. And he ordered Transport for London to issue me a refund. So the adjudicator adjudicated on 7 penalty charge notices because that's what adjudicators do. Subsequently, he also stated, because it was unlawful, that if I had paid any fees to Transport for London or any penalty charge notices, that they were to issue a refund without delay. So, cutting a very long story short, the adjudicator, so when we were aware of the scheme, which was after we received the last penalty charge notice, because they all came at once, We then signed up for the auto pay system, where it automatically took money from your bank account. So every time you drive into that area, it takes £100. So because the adjudicator had stated that it was unlawful, the LEZ, that he couldn't be satisfied that it was lawful, I've been trying to claim those fees back from Transport for London, which is being directed by that adjudicator. The only issue that the judge had on the 20th of March was that he didn't have the jurisdiction to determine what happened after that last penalty charge notice. So it was a small claims court, so he didn't have that jurisdiction to make an assessment or look at the facts, look at the evidence to say whether or not the signage after that day was rectified. He didn't know whether or not they'd scrapped it. He didn't know any of that information. And, you know, like us, he can't apply common sense. He has to look at the actual footage. So on that basis, I applied to the Central London County Court, which is at the Royal Courts of Justice, because they hear technical cases. They can hear very technical. I believe that they can look at real complex cases. Sorry, that was the correct terminology. They have the jurisdiction to look at very complex cases. But this is a fairly straightforward case. And my simple legal question to that court was, did Transport for London use defective signage to enforce against me? That was yes or no. So my case was, do the signs comply with the legislation, yes or no? And that is the long and short of this. So obviously when we got into court, what Transport for London's defence was that this is going to cost them millions if the court grants a declaration. It has to be by way of a judicial review.
Yeah.
Now, and they applied something called the exclusivity principle. And the exclusivity principle, for those that don't know, is where a judge has put a procedure in place for judicial reviews. And that's what they were arguing, was that my case should be heard by way of a judicial review. Well, this is a private law claim of restitution, and restitution is heard in the normal courts. Yeah. Absolutely. Because a judicial review, all that's going to do is look at the process. It's going to look at how they got to that decision. I have no interest in how Transport for London got to that decision. I'm asking the court to, with the facts and the evidence, I'm asking the court, do these signs comply with the legislation, yes or no? And subsequently, the judge refused to hear any of my evidence. He battered it off down to the road of a judicial review. Now, one of the other interesting points here, without going into all of the applications that have had to be filed in the courts, because with Transport for London, it's been continuous strikeout, and strikeout, which has really delayed proceedings. So how long have these proceedings gone on for now, Andy? They've probably gone on for well over 2 years that both you and I have been talking about this issue on your show. And the reason why it's taking so long is because of the amount of obstacles and hurdles and barriers that Transport for London are putting in my way. It's designed to wear me down, to break me, and to run out of money. It's a very simple process that they're using. And it's very aggressive in how you're met as well. So just to give you an example, when I went into the small claims court, the night before, they had submitted their costs to that court, knowing full well that that a small money claims court, you can't claim costs from the other party. So it was a real nasty, dirty tactic that they used against me. And this is the sort of hostility that I've been met with for the last couple of years. Very, very demanding. Every time that they put an application into the court for a strikeout, I have to read all of the evidence. I then have to formulate a skeleton argument. It goes on and on and on. So as you will appreciate, Andy, the considerable amount of time that this takes for me to read everything, check everything legally, then compile, a skeleton argument, submit that to court. There's obviously court fees as well that are involved in this. I think at one stage I've worked it out that Transport for London have, on this journey, they've submitted something like 7 to 10 now strikeout applications. In the last hearing that I just had on the 3rd of September, Transport for London had submitted 4 applications for strikeout in one hearing. So it got really confusing. You were in court that day, Andy. You could see it. I mean, the best part of sort of 20, 25 minutes at the beginning was the judge trying to sort out what applications were in front of him. What's your thought on that?
I mean, I was sat at the back listening to it all. And, at the end of the day, what people need to appreciate is you were a layperson. You were a litigant in person. You're not a lawyer. You were doing the best you could considering the circumstances. The judge that was there seemed ill prepared because, he was being told things he didn't know about. Here you are, read this, judge, before we go any further. And the lawyer for TfL was stating case president, and it seems like it was a tiny technicality that they wanted to use to, throw you to one side. In this case, steer it down a judicial review point. You did everything you could. I sat there and listened to you. You went through the history of the thing. I mean, at the end of the day, this is what it's all about. These bloody signs. What do they tell you? Nothing. So what? What? Where? When? How much? That's. And again, you set very specific precedents in your argument. You were very thorough. And I was sitting there with Howard and, everyone else thinking, yeah, no. And what did he do? Strike it out.
Yeah, he struck out the claim basically that it should be heard by way of a judicial review. Now, the thing that really troubled me about that case, and it probably troubled you as well, Andy, I actually said to the judge, didn't I? I said, have you read my particulars of claim? And I said, have you read the adjudicator's decision? And he said, no.
That's right.
I mean, that to me there, the most important part, even if he hadn't read my particulars of claim, you would have thought that a judge who was going to judge something fairly, that what a judge would do, he would look at what has been a decided matter already. My court bundle was very, very specific. You can vouch for the fact that I was able to direct him very clearly to where the adjudicator's decision was, which was in the court bundle. It was indexed. It wasn't a massive court bundle because I was fighting a strikeout. And the law categorically states as well that you cannot strike out a legally binding decision or relitigate matters that have already been decided. So the adjudicator's decision, for those of the people that don't know, if an adjudicator rules against you, your only course of action is to take that decision to a judicial review. Now, Transport for London chose not to do that. So that decision was back in October 2021. So we're 4 years down the road now. So they're well out of time. If you're going to appeal an adjudicator's decision, you have 3 months to do it. And they chose not to do it. But that is a legally binding decision that stands. And when I was in court in Bedfordshire, the judge would not tolerate anything that Transport for London had to say to him. He was not interested in anything they had to say. He said, you have not appealed this decision. It's a legally binding decision, and I am satisfied that it has been fact-finded. So that judge was really good. Like, he judged it fairly, as he should do. This judge took no notice of that adjudicator's decision, and he struck out a legally binding decision. And I'm not making this up, Andy. You were there, and I said to him, sir, I was very respectful. And I said, sir, this is a legally binding decision where an adjudicator has deemed that the LEZ is unlawful. And then he tried to downplay it, didn't he? By saying, well, he wasn't satisfied. Okay, well, he wasn't satisfied on the pretense that Transport for London were unable to provide evidence that their signs were lawful. Why is everyone flipping that off by saying that he wasn't satisfied? Because if Transport for London, which is what we will get into in a minute, had they have provided the evidence, I have no doubt in my mind, I can't speak for an adjudicator, of course I can't, but in my view, and I have no doubt in my mind, that that adjudicator would have actually declared the LEZ unlawful on that basis.
Mm. Didn't you have two decisions in your favour before this court date we're talking about? Was it just the one adjudicator decision, or was it two?
No, it was the adjudicator's decision, and where I think people have got a little bit confused is when I went to Bedfordshire County Court, the judge upheld that adjudicator's decision.
Got it.
And he said to me, had your payments fallen from 2016 to the 17th of June, I think it was 2021. So he stated from the 22nd of April 2016 to the 17th of June 2021, had my payments have fallen within that window, he would have granted summary judgment there and then. So it was very, very fair. And he said to Transport for London, you should have not been levying charges in that period. That's what he said.
Okay.
And that is actually verbatim what I've just repeated back to you. And what I can't understand is that with a judge who was so specific, upheld that decision as fact-finded, then another judge just strikes it out. Because when I put a declaration, so what I applied to the Central London County Court was a Part A claim, which was a declaration, and I'm asking the court to declare that the signs used against me were unlawful. And that also incorporates the ULEZ as well, because what I was forced to do was buy a Euro 6 lorry to transport my materials. That's forced debt onto me. That is a private right. I cannot see how a judge has said that this has to be public law. So I've appealed that decision, and I've got 5 grounds of appeal. And one of them was the actual Denton test, which is what I'm going to come back to now. So the judge used something called the Denton test, which is case law from another hearing. And what I tried to say to the judge, Andy, you can vouch for this, is that throughout all of proceedings, that Transport for London have continued to breach court orders. Every single order that there's been from the court, Transport for London has failed to meet those deadlines.
That's right.
But then I knew at that point that it was not going to go in my favour because he was sticking up for Transport for London. So I knew there and then I should have just said to the judge, do you know what, we won't waste anyone's time here. You just say what you've got to say, and we'll all walk out of the courtroom and save each other's time. Because he was sticking up for Transport for London, and he was asking me, a litigant in person, he was asking me, yeah, but what prejudice have they caused you? Well, of course they've caused me prejudice because I'm meeting all of the deadlines and they're not. So what a ridiculous question. So the long and short of it is, in this judge's view, which got me really angry, and I think I got a bit emotional whilst I was in there because I got really angry with him because he had stated, what prejudice has this caused you? And he did not strike out their claim. Now, that is a sanction that the courts are supposed to impose on you if you do not meet the court's deadlines. So let's draw this back, Andy. What is the point in having a court deadline if anyone can breach it? What's the point?
Yeah, there is none.
There is no point.
I think when you get big matters like this, the system goes into a kind of self-protection mode because you've got your situation where they're dragging it out, and we'll come to the point in just a second. But I'm supporting and trying to publicise another big court case with potential big ramifications going on as well. And again, it's the system trying to protect itself, grabbing hold of another litigant in person, putting them in front of an appeal, trying to drag it out with time, trying to drag it out with costs, hoping it will go away. I mean, the judge said, didn't he, if he was to find in your favour, the consequences for TfL would be catastrophic. Now, there's a case that I came across when I looked at this afterwards, and it was an individual who had a problem with something a council did to them. And it all went to court, and the council said, well, if you find in his favour, then we're buggered, basically. And you know what the judge said? And it's very famous: let the heavens open. What he basically said was, it's my job to uphold and interpret the law. Doesn't matter to me what happens to your council. You should have done the right thing in the first place. And I'm reminded of that when we're talking about, you know, what's going on now.
Well, exactly. So you see, on that basis, had I had the judge now, if the roles were reversed and I was breaching court orders, I'd have been told to jog on without a shadow of a doubt. Yeah, I'd have been told pack your gear and go. Yeah, it would have just been all one way traffic. If that was if I had breached all the court orders and their barrister was sitting, in fact, I think he was a King's Counsel that they'd hired for that day.
He was, yeah,
I think he was a King's Counsel, and he would have said to the judge, "You need to impose sanctions." And I have no doubt in my mind that that judge would have imposed sanctions. Now, I'm not going to sit here and play the whole conspiracy theory route. I'm not going to play the whole conspiracy theory card. But one of the troubling things about this judge was the fact that he was a retired judge. He was sitting in retirement. And that's the thing that I can't understand. Why is a judge sitting in retirement listening to my case? And it's a case of this magnitude where he hadn't read any of the documents that were put in front of him. Now, I understand that judges are very busy. They're under a lot of pressure. I sympathize with that. But they do get, I think, time before you come into court. I believe that there's they call it a legal name, where a judge can sit there and read what's in front of him before you come into the chamber. So, but it was just clear and it was evident that he hadn't done that. So, like I say, because of the Denton test, when he refused to impose sanctions on Transport for London, that's when I knew that I was not going to get any form of justice that day. I knew it, I felt it, and he was quite hostile, the judge, as well. He wasn't at all friendly. It was kind of all one-way traffic, wasn't it? And when it came to me speaking, he looked completely disinterested, and that's what a lot of you guys picked up on. He looked disinterested and he looked very, very bored. But when it came to the case law that Transport for London was citing, he was sitting there taking notes, writing everything down. But when it was me, he didn't write anything down. So, I mean, look, people can make up their own minds. I'm not going to sit here and say everybody feels sorry for me, blah, 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 because I'm just not going to do that. At the end of the day, the facts speak for themselves. It was a private law claim, and it should have been heard in that court. That day, it should have been heard without a shadow of a doubt. So the Denton test, just coming back to that, it's that he said, no, it has to be specific to these proceedings. The Denton test says all proceedings.
Right.
Has the defendant or the claimant complied in all proceedings? That's what it says in the Denton test.
Right.
But he said only in these proceedings.
I think there's another law as well, which I read the other day. Something or other due process. You're entitled to due process, and in my view, you never received due process. You were shifted to one side, so the whole thing's bad. Also, I need to file court proceedings against somebody today. Not a matter I go into. It's a small claims matter, but very straightforward. Online, how much, why, pay the fee, done. Go to court. It's a private matter. Chicken fee compared with the sums that you're talking about, granted, but similarities with not the consequences that you're dealing with. I mean, shoving it down a judicial review route. I mean, how much, just to clarify it for the audience, how much are we looking at? It's literally thousands, isn't it?
It's tens of thousands of pounds, if not hundreds of thousands of pounds. If it goes to the Court of Appeal, my understanding is before you can even get to the Court of Appeal, you have to do something called case management, which is where they put a limit on the fees that the other person is liable for. So they have to put a limit on that, and at that point, I think you have to prove that you've got the money to move forwards. I mean, in a way, it's a good thing so that people don't get themselves into serious amounts of debt. I mean, the sort of figures that I've been quoted going into the Court of Appeal potentially could be looking at about 200 grand.
Right. I mean, you know, there's members and subscribers of this channel which very generously donated to the crowdfunder that you set up when all this first started. And you know, there was a few thousand quid put in there, but the level they're trying to bring this to, it just doesn't touch the sides, does it?
Well, no, and I mean, you know, if I just sort of go back to because you know I don't mind talking about this now. So I mean, I go back to I issued Transport for London a statutory demand for that money. This was before it got to the Small Claims Court. And they still didn't comply with the statutory demand for the money. So I put a winding up petition in, which was phenomenal money. You remember I sent you all the paperwork for that, and you were like, wow. It wasn't a route that I wanted to go down with Transport for London. I genuinely didn't want to go down the route of winding up Transport for London. And for everybody out there, they can see that Transport for London is on Companies House. It's a corporation. It's a company. However, the Greater London Authority has given them statutory protection. So that route there was a route that was closed off to me. So that was a big waste of money. But at that time, you don't know that, you see, until you submit those papers to the court. And the court pushed back and said, you can't wind up Transport for London. So then that was then when I went down the route of, at that point, I was like, you know what? I can't be bothered with this. I really thought at that point, there's been many times, Andy, when I thought, I can't be bothered with this. The £2,100 that I'm trying to get back for Transport for London, in the grand scheme of things, it was, 4 or 5 years ago. But I made a commitment that I was going to do this, and people have supported me doing this. And I would like to think that I'm a man of my word, and I'll see this all the way through to the end. Yeah, and you know, I've come under such attack from people, you know, despicable. I'm a fraud. All of these sorts of, you know, things, the name calling. I've received death threats when my family have been in the car, when I've picked up the phone on loudspeaker, my family's in the car and have had to listen to me getting death threats. You know, I don't think people see how this side of what goes on, you know, how stressful it is, the impact that this has on your personal life, the amount of days off work that I've had to have, time off work, to read all of these things that they put in front. These people, you know, these lawyers, that, you know, this is a full corporation with resources, a massive legal department. They're fully financed, well-resourced, of our money. Of course, it's our money that they're using. And like I say, just them putting in 10 applications, it was, don't quote me on that, it was about 10 applications. I don't have it to hand. You know, you're roughly looking at nearly about £5 just in applications. They don't care because they've got an endless supply of money. I then have to put an application in to counter that application. You know, so the money, literally, in terms of, you know, my time and energy and people that have supported me through this, I cannot thank them enough. But in terms of the legal sense, yes, it got us to where we are now. That's what I would say. But once I have a clear understanding of where the direction that we're going to go in, obviously I've asked the court to appeal that decision. Let's see what they come back. If it's got to go up to the Court of Appeal, that's when the astronomical money will come in, and then there'll have to be serious crowdfunding, you know, to do that. Because a lot of people have said to me, no pressure, Noel, but you're our only hope. And that's what, and that's very humbling for me to hear that, because it's what I've uncovered about these signs. And the ULEZ and the low emission zone, they're completely different to the LEZ, which is what I won. And it's very complex for me to actually explain how the ULEZ and the expansion is unlawful because they're different. And one thing that people need to understand is that you have the legislation and then you have the signs that have been authorized by Department for Transport. But Department for Transport, when they authorize a sign, they work from the legislation at that time. So whatever is the governing legislation, they have to make sure that those signs meet the requirements of that legislation. Yeah. The size, the dimension, the information that that sign has to have, etc., etc. So that's just for people a very brief understanding. So what that would be, you have in the regulations, which is the Road Traffic Signs and General Directions 2016, they are known as prescribed signs. The Department for Transport, the authorization gives you something called non-standard signs. Yeah. But the Department for Transport, the Secretary of State for Transport, authorizes those signs using the Road Traffic Act, 1984, section 44, section 64 and 65 of the Road Traffic Act. So that empowers the Secretary of State to authorize and legalize those signs. Yeah. Does that make sense?
Yeah.
Because this is 4 years of studying, so it's all in here. You know, the acts and all that sort of stuff. It's all in here. So I just wanted to make sure that that was quite clear, because it does get quite confusing, and people they say yes, it doesn't give you enough information, and I completely agree with that. But you have to understand the law and the legislation as to why it doesn't give you the correct information. And it's quite complicated how it's all structured. So I'm thinking what we should do is show everyone tonight, Andy.
Absolutely. What document do you want to put on first? You got the 2 screen dumps and then the PDF.
Right, so I think what you need to do is bring up the first page of the sign. So if I just explain to people what it is before you bring up that particular document. So when I appealed against all of these penalty charge notices that came, I couldn't find an authorization. I could see that the LEZ sign was not a sign that was prescribed in the regulation. So I then thought, right, okay, it has to be a non-standard sign. So at that point, I started running searches to find the LEZ authorization, and I quickly established that it wasn't an authorized sign. So the reason for this is, and we'll get into this now, so the LEZ was authorized by the Department for Transport back in 2008.
Okay.
So at that time, the governing legislation, the legal framework at that time was, that time was the Road Traffic Signs in General Direction 2002. So because they were authorized in 2008, they worked to that legal framework, yeah? Then what happened on the 22nd of April, 2016, the regulations changed. The regulations were updated to the 2016 regulations. Now, Andy, what do you think Transport for London would have to do? What do you think they would have to do when the regulations changed?
Update the signs.
Exactly. Update the signs or update their authorization.
Update the authorizations, yeah.
They never did that.
Okay.
They never updated it. So what we will do is, if we could bring up the first page of the authorization, and then as you work your way down the bottom there, you can see where it says about the 2002 regulations. Can you read that bit?
Yeah. The 2002 regulations means the traffic signs regulations and general directions 2002. References to a lettered or numbered drawing are to the drawing annexed to this instrument, which is so lettered or numbered. You want the bit underneath?
No, you don't. You don't need to do that. So if you pull up the second page,
okay,
which confirms to everybody the date that those signs were authorised. What is the date?
17th of July 2007.
There you go. So they implemented the scheme in 2008, and the signs were authorised in 2007.
Got it.
So can you bring up the PDF?
Yep. I'll just make this a little bigger. There we go. It's as big as it'll go.
Okay. So will you read out what it says in... So for everybody that doesn't know, so that is the Road Traffic Signs General Directions 2016. That is the circular right there. So that is all of your legal framework right there in that document. And what does it say, Andy, in 2.1 of that introduction?
Okay. Just to say, I've just shared that in the comments if anybody wants to go and read it at some point. That's in there now. And what it says in 2.1, the traffic signs regulations and general directions, TSRGD 2016, came into force on the 22nd of April 2016. It revokes the traffic signs regulations and general directions 2002 and replaces them with an updated, revised and consolidated TSRGD. The TSRGD amendments made in 2004, 2005, 2006, 2008 and 2011 have been revoked and incorporated into the new TSRGD.
Well, what do you make of that?
The dates don't marry up, do they, my friend?
No. And that's why they did not provide the evidence to the adjudicator, because it was an out-of-date authorization. So they are saying, Transport for London, that they didn't because of an administration error. Yeah. They didn't because they couldn't, Andy.
Yeah.
That's the simple fact. And when the adjudicator concluded, and he said, I cannot be satisfied that the low emission zone is lawful, so therefore no penalty charge applies. He then goes on in his conclusion to categorically state that Transport for London have not satisfied him that their signs meet the requirements of the TSRGD 2016, nor are they otherwise authorised as non-standard signs. So he didn't say in there, when he was summing up the adjudicator, he didn't say 2016 or the 2002 regulations. He didn't say that. It was very specific that they have not satisfied him that those signs were lawful beyond that point. So the signs were lawful from 2008 to the 22nd of April 2016. But when the new governing law came in, now at that time, my legal knowledge was not what it is now. And even I know that when new regulations come in, and that's from me being in construction with all the health and safety legislation that comes in, I know that when new regulations come in or new legislation comes in, that it revokes the legislation before. That's the whole idea, and that's the whole concept of it. And all Transport for London keeps saying to the press, our signs are authorised, because GB News, they've put in a right of response to Transport for London, and they're saying the signs were authorised in 2008. Yes, they were authorised in 2008, but you did not reauthorise those signs in 2016. And it categorically states in the legislation that those regulations are now revoked.
Therefore, making the entire thing unlawful and taking money on false pretenses.
Exactly. So they have been charging people from the 22nd of April 2016 right up until the expansion, which was the 29th of August 2023. So in that window, every single penny that has been paid to Transport for London is unlawful. And that is the reason why I'm getting shut down.
Absolutely. Because, you know, people need to realise the consequence of this. If it was found in your favour when we were there, did he say a president would be set, or the consequences would be catastrophic because they'd have to refund billions? It'd crash the whole lot, wouldn't it?
Well, yeah, I mean, so the judge did say that, you know, the financial consequence. So, sorry, the barrister said to the judge that if they grant the declaration, millions would have to be paid back in auto pay charges. And he said, and it would cripple public services. That's what he said. So to me, that was emotional blackmail to the court.
Yeah. Yeah.
Now, you've seen sight of that, haven't you? I have sent that to you in black and white. You have seen sight of that, and you also heard that in the court. And when the judge was summing up, he also used that as part of his judgment as to why he said that this has to go down the route of a judicial review. Now, when I came out of the courtroom, because ITM were there, when I came out, it was that Simon London, I think it was, that was interviewing me. And he said, yeah, but surely you've got to realise that a district judge, you know, can't make that decision about bankrupting Transport for London. And I said, look, with the greatest of respect, Simon, they didn't care about bankrupting me. So why should I care about bankrupting them?
Well, it should be very cut and dry, shouldn't it? Is it legal? Yes or no? If it isn't, then it needs to be dealt with, you know.
And also the ULEZ signs, even though I haven't proved it in court, but yet again, they're not allowing me to provide the evidence. They're shutting me down, because we all know that once the evidence is actually presented in court, the judge is legally bound to make a judgment on that evidence. And I have mapped it all together, and I am 100% confident that the ULEZ signs are unlawful, and I'm also 100% confident that the new ULEZ and low emission zone signs are also unlawful. And if I can get the chance of a fair trial, I will prove it beyond reasonable doubt. If we can get this into court and get a hearing, get a trial on this, I can guarantee you that we will win. Because
at the end, go on.
Sorry, I was going to say, because road traffic law is prescriptive. There is no interpretation. For example, if you go to court for speeding, what did the sign say? The sign said 20 miles an hour, 30, you're over the speed limit. There is no interpretation. The signs are prescriptive. It's all one-way traffic. And it's exactly the same as these road traffic signs. There is no room for interpretation. They're prescriptive, and you have to follow with what is written in black and white. And that is the reason why I'm being shut down. And yet again, what I'm going to need, Andy, when the time comes, is everyone to get behind me, and support me through this. Definitely. Because I've never once said, if Transport for London pay me, they've got to pay everyone else. This is what Transport for London are saying. Their lawyers have been saying this. They're the ones that have been saying it. I've never said it. I've just stuck to, I'm owed £2,100 from the auto pay charges, and I was forced to take on debt by having to buy a compliant vehicle because of signs that have been deployed that are defective.
Absolutely. I mean, did you say that you're still getting knocks on the door from this 11 grand, even though they deemed it was, you know?
So exactly. So what I asked the court for as well was an injunction restraining Transport for London for using the same signs against me. It was a narrow injunction And yet again, you could see that the judge had no interest in that, because I said to him, yeah, but judge, after that adjudicator's decision, which was in October 2021, Transport for London came after me again in March 2022. And I've got all the evidence there. It was all in the court bundle, but he had no interest.
Absolutely. I mean, at the end of it as well, you were told you do have the right to appeal. You immediately said, I want to appeal. He said, on what grounds? You said, on what grounds? No, not interested. Judicial review, go away, off your pop. So, and then he said, take advice, you know, come back. So, to be specific, what's next? What are we going to do next? Where is this going now?
So I've appealed with 5 grounds of appeal.
5 grounds.
Yeah, so we'll have to see what the result will be of that appeal. Also, as well, you know, I don't want to give her name out at the moment as it stands, but a very well-known public figure in law is going to represent this case as well.
Yeah.
Because, yes, I do know the law, and I know the road traffic signs inside out and backwards, and I know the Department for Transport's conditions of those authorisations inside out. But what I don't know, Andy, is advocacy. I'm not trained in advocacy. I own a scaffold company. You know, I'm not trained in advocacy. Barristers and lawyers, they're all trained in advocacy. I'm not. And as you could see, they were trying to tie me up in knots using all of the court procedure rules.
Yeah, I mean, I know who you're referring to, and you know, you definitely do need the assistance at this stage. There's no two ways about it. What has this done to your business? To tell people what this has done.
I mean, my business was absolutely thriving before I started all of this. I think I've lost contracts because of the environmental policy, because construction is very, very heavily scrutinised on your environmental policies. It's all part of your accreditations. I've lost a lot of council work, and I mean, it's through no fault of our own. We didn't let anyone down. We didn't finish a project on time or anything like that. So I've lost a lot of work in regards to actually doing this. And I think it's a cross between the environmental policies and people just not wanting to be associated with what I'm doing here. And I think the flip side to the coin is because I've had to invest so much time into this. I mean, I think I've run a tracker. I think I'm at something about 1,700 hours of research and studying that I've done in relation to this. And I'm not asking for sympathy, you know, because this is my choice. Nobody's put a gun to my head. But it has had a very, very, very detrimental effect on my life. And like I say, profits have dropped quite considerably. And that would be reflected on Companies House. It's not something that I'm making up. And yeah, it's been very, very, very challenging, very, very challenging time for me. But you know what? You've got to push on. You've got to be mentally robust. And I just have to stand up to any adversity that comes my way. And it comes at great risk to me because I'm obviously liable for government's costs. Winner walks away scot-free. Loser has to pay costs to the other side. And you saw as well that they were awarded costs as well in court against me.
Well, the other thing as well, which I thought was very underhanded, yes, you were awarded costs, but
no, I wasn't awarded. They were awarded costs.
They were, pardon me, they were awarded costs. And what I thought was underhanded was their barrister mentioned the crowdfunder.
Yeah,
you know, trying to up the
ante.
Get more money.
The cost he was trying to get more money.
Yeah, exactly.
I mean, the only thing that I can say is that the judge did bite his head off for that. You know, the judge, he was not happy about that because he was trying to ramp up his costs.
Yeah.
He said he's got a crowdfunder, and then the judge, you know, the glasses went down. And I think the judge sort of thought, hang on a minute, you're taking the piss here. You're really taking the piss by saying that, you know, we had a crowdfunder to hit me with more costs.
Yeah. Yeah, I think that's the only part he was on your side there, really. Apart from that.
Funny? Yeah, I mean, but isn't it funny? Then the judge kind of changed his tune towards me, didn't he?
Mm.
He became a bit more friendly, because then he was like, look, you know, go away, you know, powder your nose, you know, come back. What do you mean come back, mate? What do you mean? This isn't like bad table service that I've had in a restaurant where you've served me up a steak not to my liking. What do you mean come back? What does that mean?
Yeah.
You just told me to go somewhere else. Why are you telling me to come back? It just made no sense at all, Andy. No sense at all.
Well, also, you know, somebody came in which could have potentially assisted you at that point in time, completely barred from doing so. You know,
they refused. Yeah, absolutely. Yeah, they refused, because I believe that if she was allowed to speak to the judge, things would have gone completely in another direction.
Yeah, and it was obvious they weren't allowed to be going in the direction that we wanted.
No, because I mean, this individual is absolute firepower, and she has categorically said that she will represent this case. So I think both her and myself together, and I've got another lawyer as well that's helping me in the background. She's amazing, absolutely amazing. I've got two really strong women, you know, that are supporting me through this. And I think it will get to a point again where I think the public are going to have to, you know, get behind me, support me, you know, through this process and get this over the line.
Absolutely.
But I want to keep reiterating, it is a private law claim. You know, this is not a class action. This is not a judicial review. I'm focusing on the signage that was used against me was unlawful.
And therefore, it has cost you. That's what it's all about, a private claim. And I think they're trying to steer it down another path that it isn't, to get rid of you. You know, price you out of the game.
A judicial review is not a money claims court.
Yeah, correct.
It's not a money. So why I've been sent down the judicial review route is just bonkers.
Yeah, absolutely.
You can get a Sorry, mate, go on.
No, go on. I cut across you. There's a delay.
Yeah, you can. You would get awarded costs in a judicial review, of course you would. But the £2,100 of auto pay charges that I'm still owed, you can't get that in a judicial review. So I have no idea why the judge has said it's got to be by way of a judicial review. But I mean, look, it's over. It's done with now. There's not a lot I can do. He made his decision. That's what judges do. Judges get things wrong. They're human beings. So we'll put it down to that I think maybe he got it wrong. And it's not that I know he got it wrong. So it's a case of now, you know, getting this appeal.
Absolutely. What I want to do at this stage, Noel, is just whiz through some of the comments very quickly. They're not exactly questions, just some good wishes and that. Okay. Finish up, and then we can go and have a drink, sleep, eat dinner, or whatever else there is to do with the rest of the evening. The lodger, Susan Hall, ripped into corrupt Khan the other day. Once again, she made him look like a mug. And I think that's the liar that he is. One thing I love about the London Assembly, none of them ever answer a question in a straight way. It's always evade. And he's probably the expert. Terry McDonald, I'd love TFL to have to pay the fines back. It would be brilliant for all concerned. I think that's what they're worried about, isn't it? Because if they paid you back the money you're owed, they'd have to pay back the money to everybody they're owed that they've taken under false pretenses.
Absolutely.
That's quite the statement. Khan must be booted out. I'm not going to read the rest of that, but yes, I appreciate the sentiment. Good wish there from Blood Nose, my moderator in the background. Noel Willcox is a top man. Hello, Noel. That's Blood Nose from America.
Hello there.
So this is going international. It's a Khan scam. Yes, absolutely. Thank you, Dean. We know that. I mean, I did a lot of work on this channel in the beginning, looking at the air quality around London and comparing different dates and everything. And I think Howard Cox went down the underground, didn't he, with one of those meters? And none of it makes any sense. Sabina, did you know TfL is in debt for millions of pounds? Well, they keep getting bailed out, don't they, Noel? And you look at what he's wasting the money on. Someone should be asking Kant where 450 million quid's gone. I'm not even going to comment on that. It's probably more. BBR, TfL are worried. You all know it, and Noel is right. It comes down to money. Even the judges don't seem they want to rule on this. They are scared. I think it's the establishment going into protection mode. That's what it seems like. And this and another case I'm helping to advertise and support as well. And the funny thing is, and we both looked, I mean, I will say it because it's not affecting me. I looked at the history of this supposed judge with 40 odd years of experience. Couldn't find anything on him anywhere. It was just a mystery, but there's probably a reason for that. Cheeseface hates the English due to the reception he received when he arrived. He's under investigation now. Not sure who you're referring to there, Cheeseface. White families have been waiting 19 years until it didn't happen by chance. Yeah, I think we're diverting off the subject there just a little bit. Thanks for all your efforts, Noel. That's Play Apps. Another nice comment for you. It's all a revenue scheme, nothing to do with congestion. I think that's more than apparent. The traffic's worse as it was 10 years ago. I mean, you've got all the LTNs and everything as well, haven't you, that they're trying to actually deal with. Thank you for the £2 super chat, Tony. Very much appreciated. Hardly ever makes the news. First Uber to make everyone aware. Get loads of views, especially now the pink ladies are protesting. Yeah, that's another story for another time. Cheeseface, thank you. Whitewash, you had no chance. Judge had made decisions even before it started. Well, I think that was rather apparent with the fact he hardly read anything that you presented to him. So it's like a predetermined judgment, wasn't it? Last one, we have other powers are working against you, Noel. And again, I think that's quite apparent. And no real questions there, just a few comments. Thank you, everybody, for them. And yeah, we're coming up to the hour. And I'm going to say, please hit the like button, subscribe to the channel, and share this everywhere. People need to be made aware of exactly what's going on. People need to support Noel. People need to get behind this. And then I'm sure we will address this again in the very near future. I'm certainly behind it. I have been from the start, and I'm certainly going to continue to the end. And as I like to do every time, Noel, as you well know, give my guests the last word.
Oh, sorry, mate. I was expecting a comment to come up. Yeah, I mean, look, like I say, just thank you to everybody, the support that I'm getting. I mean, I've got so much support behind me, and it really is inspiring me to just keep going, keep continuing, and just doing the right thing, and I do believe that righteous will always prevail. I think, justice will always be served. And look, I think this is going to be a long road. It's going to be a long battle ahead. For me in particular, I just have to mentally focus on the task in hand, and not get distracted with other things. And like I say, with everyone supporting me, I'm sure that I will get there in the end.
Absolutely. There's one more. I know I said I'll give you the last word, but I'm going to have it. There's one thing that I've noticed with things like this. It's very much a public interest element, because if you look at Noel's situation, we walked out of the court and there was media waiting for him. GB News, ITN, as you said, and a couple of citizen journalists. There was me. I wouldn't call myself a citizen journalist. I'm just a cabbie with a gob. David Atherton, he was there as well. And obviously you had support from Susan Hall, Howard Cox. But with cases like this, where there's potential consequences for the establishment, sometimes they get swept under the carpet. Sometimes they try and hide it in a back room somewhere to try and drown the public interest. And it's very important that courts and the judiciary see a public interest in anything like this, potentially where there's big consequences. You know, we've talked about Graham Moore on other live streams with regard to what's going on with the voting irregularities, another example of public interest. So if you see strings like this, listen, share, understand, talk, tell. You know, all the while they can't hide from this anymore, we might finally get somewhere. So keep chatting. Well, thank you very much. It's a good night from me and a good night from Noel. I'll be back tomorrow, and I look forward to talking to you soon.
Take care.